Let's look at Arizona's own rules for a valid prenuptial agreement. Then fill out a sample one together. Here's what Arizona requires for a prenuptial agreement. The agreement must be in writing. It must be signed by both parties. No separate consideration is required for the agreement to be enforceable. Beyond the marriage itself, neither party has to give or promise anything of value in exchange for it. It becomes effective upon the marriage of the parties. It is not enforceable against a party who did not execute it voluntarily. How each party's property and financial obligations must be disclosed, and what a failure to disclose does to the agreement, is set by state law. That disclosure can be waived only voluntarily and expressly, in writing. Whether the agreement is unconscionable is decided by the court as a matter of law. If the marriage is void, the agreement is enforceable only to the extent necessary to avoid an inequitable result. It may set each party's rights and obligations in any property, whenever acquired. It may cover the right to buy, sell, use, and otherwise manage and control property. It may set how property is divided on separation, divorce, or death. It may modify or eliminate spousal support. It may require a will or trust to carry out the agreement's provisions. It may set ownership and disposition of life insurance death benefits. It may choose the law governing the agreement. Any other matter may be included unless it violates public policy or a criminal statute. A child's right to support cannot be adversely affected by the agreement. A premarital agreement is one made between prospective spouses in contemplation of marriage, effective on marriage. The parties must be prospective spouses, and the agreement made in contemplation of marriage. Property means any legal or equitable interest in real or personal property. Property reaches present and future interests, whether vested or contingent. Property reaches income and earnings, not just principal holdings. After marriage, it may be amended only by a written agreement. After marriage, it may be revoked only by a written agreement. An amendment or revocation must be signed by both parties. An amendment to the agreement, or a revocation of it, is enforceable without consideration. Nothing of value has to be exchanged for the change to take effect. Although once the agreement is in effect, the change must be made in a writing signed by both parties. Start with the effective date, the day the couple plans to sign before their wedding. The agreement itself calls this its effective date. Per the requirements, it only becomes effective once the marriage happens, so this date marks when the couple signs, not the wedding day. Next, enter each prospective spouse's name and mailing address, exactly as it will appear on the signed pages. The agreement calls each person the prospective spouse 1 or the prospective spouse 2, terms carried through the signature block and the schedules ahead. Each spouse also acknowledges being advised by their own lawyer and receiving the other's full financial disclosure, the same disclosure duty the requirements covered. Further down, a clause lets the couple pick which state's law governs their own agreement. The same clause names a state again, for which courts would hear a dispute over it. Since this is an Arizona agreement, both blanks are filled with Arizona, matching what the requirements called choosing the governing law. The attached schedule lists each person's finances. Spouse 1's copy shows a bank account, a car, and some jewelry as examples. Filling out this schedule is how each spouse discloses their own finances to the other. The disclosure the agreement's own acknowledgments describe earlier in the document. The full schedule also covers income and other belongings for a complete accounting of what each spouse brings into the marriage. Spouse 2's copy follows the identical layout, filled in here with a different sample balance, vehicle, and valuable item. Each spouse reviews and signs their own schedules separately, confirming they looked over everything listed before it becomes part of the agreement. Matching complete entries on both schedules let each spouse rely on the other's disclosure, the voluntary disclosure the requirements mentioned. The agreement closes with a signature line and a dated line for each spouse. Signing here executes the agreement as the requirements described, so do not sign until you are both in front of a notary. Fill out your own prenuptial agreement free at FormsPal. No sign-up required.